In California, you generally have 2 years from the date of the incident to file a product liability claim. If a product is used in a way that's not necessarily intended, the manufacturer of the product can still be held liable if it's foreseeable that the product would be used in that way. That's very important because a lot of people think that if they misused a product, then automatically they have no claim, and that's not necessarily the case. If someone's injured using a product and they want to determine whether or not that product was defective, then the product needs to be tested by an expert in that field, and the expert will be able to tell us if the product is defective or, in fact, the design is defective. The basis for a product's liability claim can be twofold. It can be either manufacturing defect or design defect. A design defect would involve design that's poor. For example, the Ford Pinto cases. The Ford Pinto was a poor design. It was manufactured according to the specifications set forth by the engineers, but it was a bad design, which resulted in many deaths. An example of a manufacturing defect would be an exploding Coke bottle. The Coke bottle has been used for years and years and years. The design itself is inherently safe. If someone at the bottling plant puts too much pressure in that bottle, it could cause it to explode, which would be a manufacturing defect because the design itself is safe. It's just that someone in the manufacturing process made a mistake. If you're injured by a defective product and you can prove that the product was actually defective in design or in the manufacturing process, then you'd be entitled to any of your medical bills, any of your future medical bills, whatever loss of earnings you've sustained and whatever loss of earnings you may sustain in the future. In addition, you would be entitled to the pain and suffering and or mental distress of knowing that you've been injured as a result of this negligent design or manufacturing process.
At ST & Baumberger, all of our cases are handled on a contingency fee basis, which means that if we don't recover any money on your behalf, there's no fee for our services. If we take your case, we work on your case, and we incur thousands of dollars of money on your case, but we don't recover anything on your behalf, there's no fee for our services.